important role. The question about, absolutely, it's a great question, because I think, and I'm increasingly, I think this is where I'm at on this, is that how many times this afternoon have we referenced the Good Friday Agreement? And we keep talking about the Good Friday Agreement. But some of the biggest debates that are going on the island at the moment, about, for those who feel that it hasn't been implemented, there's still bits of it that are a work in progress. Those who feel it's been there, you know, the puzzle has been the jigsaw, whatever analogy you want to use. And I think those debates continue. And for those who say, well, it's been under-enforced or whatever, the logical next step is, well, what can I do about that? So if the argument is there's been a breach of the Good Friday Agreement, one of the things I think we're discovering, and I think it should shape the approach of the Irish government in the time ahead, and why there's an onus responsibility, and I put it strongly as this: I think more legal hard work needed to be done on tying down legally aspects of that agreement. Because if you look, and I know this has been done at the British-Irish Agreement, which is the international agreement between UK and Ireland, it's very light on enforcement. You know, what do you do if you're an Irish government saying the British government is in breach of the Good Friday Agreement? Well, it seems not very much in terms of actual legal enforcement. And I think that's a big, big problem. Now, what we found last year in relation to litigation around Brexit was the same question. Many of us, myself, teaching, working in Belfast, teaching constitutional law, we all thought something really legally significant happened in 1998. The UK has become a more constitutionally, legally pluralist place. Scotland, Northern Ireland, Wales, the old traditional UK model is passing away. But what we found out last year was, that wasn't seemed to be the case. The Westminster Parliament is very much still supreme. Very much, in some senses, working out of a command and control model from the centre. And that more constitutionally, legally pluralist understanding that we all thought we had actually sort of fell apart. And I think that's a big problem. So I think in any negotiations, wherever they're happening, at the EU level, in terms of power sharing in Northern Ireland, or wherever, there needs to be much harder thought given to putting those principles we're talking so much about this afternoon on a firmer legal footing. So we're all not left saying, well, this thing seems to be being breached, but we don't seem to be able to do anything about it. And I think that's an urgent, right? Because I put it even more, maybe melodramatically. There will get to a point with the Good Friday Agreement where there's only so many times you can say that one of the participants has left the building. And I think there are moments in the last few years, candid in my view, that the British government has simply left the building in terms of the Good Friday Agreement principles. And if you can't do anything about that, that's a big problem. That's a big problem for the Irish government, and I think that needs to be urgently addressed. So more thought about law from the perspective, of course, of an academic lawyer, with all the flaws that academic lawyers have.
Sure. Could I just come back on that very briefly? Very briefly. Thanks, Colin. It's a fairly insightful answer in a way, but I'm wondering, just in terms of the mechanics of that, if you have a view on the mechanics of that, because I would share the sentiment of what you have said in terms of an Irish government needing to challenge that, not just as co-guarantors, but co-defenders. You would like to think, or in this instance, maybe only the one defender of the Good Friday Agreement. So, I mean, do you see a role for an Irish government as the negotiations progress in terms of arguing with European colleagues around, or do you see other avenues, if there are any, for redress around not just the failure to implement elements of the agreement, but also a potential unilateral alteration, as suggested by the Constitutional Affairs Committee?
Professor, if you wouldn't mind being quite brief, because I'd like to move on to your two colleagues.
Look, I've thought quite long and hard about it on the legal side of it, right? So let me put it like this. If you're working on a future legal instrument, whether that's a new, let's say that some of the things we're talking about today and in the context of this committee, you want to do legally through a new British-Irish agreement in the far end of all this, then whoever's involved in drafting that legal instrument needs to be giving much more thought to issues around enforcement and issues around implementation, I think, than is currently the case around the Good Friday Agreement. I put it as strongly as that. I mentioned earlier about the EU and the draft negotiating guidelines sounding like it's inserting itself into the guarantor type territory. So if there's a withdrawal agreement, around all of this and whatever happens around this and the unique and special status arrangements, we need to give much more thought to not being in the position where we're sitting saying somebody is in default in relation to agreement, somebody is not respecting some of the basic fundamental principles, and we can't legally or any other way do anything about it. So whoever is involved in those conversations, the lawyers, the drafters, or whatever, people, they need to be thinking about how do you call it when somebody is in default of an international treaty. So that's... Yeah, just a few other points just to finish up very, very quickly.